In 1945, when the UN Charter was drawn up and accepted, the nations of the world had tired of war, and they felt that there should be an international criminal court to deal with the crimes of war, including aggression was the first crime, and they should have a committee set up to draw up a draft code of crimes, including the crime of aggression, and eventually we would have the rule of law applying to the situations which gave rise to the World War II, in which over 100 million people were killed. I know some will contest the figure. Nobody knows how many people were killed, but I know what I've seen. I've seen people dumped with bulldozers into ditches. I've seen people die of a broken heart, of disease, and so on. So we were trying to change that. Then those who didn't want to come under the control said, first we have to define aggression. Well, you'd say, what's so difficult about that? But lawyers, as you know, can quibble for years about the definition of a word or of a sentence, and they were demonstrating their skills. Why? Because they knew their clients didn't want to accept the terms. The big powers were not ready then, and are not ready now, to accept international controls over their decision when to use armed force to protect their national interests. Go then to the smaller nations who are more inclined, they are not going to commit aggression, and ask them to write it into their law that it's a crime punishable. We will have some measure of success there. But take another train, an express train, I call it a crime against humanity, which was also condemned at Nuremberg as a supreme international crime. Aggression was a supreme international crime, but the other crimes against humanity included all the other offenses, rape, murder, pillage, etc. If you call it a crime against humanity, it is not subject to Security Council control. They could, of course, always intervene in any conflict and assert their power, but they don't have to, under the Charter, act as they do in connection with aggression. So you bypass the Security Council by giving it a new name. You also have with it the benefit of no statute of limitations to crimes against humanity. You have the benefit of more comprehensible to a public, because nobody wants to say we're in favor of crimes against humanity. The third approach, which is going through the roof, is to call it another appropriate name, a crime which is subject to universal jurisdiction. That means these are crimes which are so despicable that they should be punished by any court, anywhere, which apprehends the perpetrator. That's where the lawyers come in. Write a law review article. What are the parameters of universal jurisdiction? What are the parameters of other inhumane acts? What are the pros and cons? Good law review student can contribute to the knowledge in that field by beginning to study it and seeing whether we can move forward on that. The fourth step, of course, is go to the street. I think that the public, particularly young people, will not tolerate a system, for long anyway, where there is no way of bringing to justice people who have illegally been responsible for using armed force, knowing that it will inevitably kill large numbers of civilians. If the legal institutions are not competent and haven't been built yet, the people who have to go out and die for that cause, I mean you, we're going to say, hell no, we won't go. I saw it in Vietnam, and we may yet see it again. But let us try the legal route and proceed, even if it be slowly, to build up our legal institutions so they're clear. It is no longer the right of anybody, any leader, to kill large numbers of people because they don't share their ideology or their religion or their race or their color, which is what drove me in when I was 27, a long time ago, to work for, and I'm still working for it, and I appreciate your help.